be continuing our discussion related to issues specific to women which have been in the news for last few years, last couple of years. So, in today's session, we are going to discuss about adultery, the recent Supreme Court judgment on adultery. Apart from that, we will also look at the recent judgment related to triple talaq, and again after that the government initiated a bill. It also initiated an ordinance. What are some of the key provisions of that ordinance bill? Apart from this, we'll also look at another issue which has been in the news, which was also in the news last year. We will be discussing about female genital mutilation. So again, there was a PIL filed that is right now with the Supreme Court. So again, what are the different issues involved here? What is female genital mutilation? Among whom it is prevalent? What are the other issues over there? So all these things we will be discussing. This particular topic can become relevant. It has been referred to the constitutional bench right now. So in few months or so, it can become relevant. So that is the reason we are going to discuss that. Apart from that, another major controversy last year has been related to temple entry. Women's entry into Sabrimala temple. So there was a Supreme Court judgment, and after that, what happened? So that also we are going to take up. So all these key things, all things that remained in the limelight last year, we will be taking up. So first thing, the judgment related to adultery. Now first of all, we need to understand why this particular thing was in the news. What was exactly the case? Now, there was a Supreme Court judgment last year, 2018, and this judgment decriminalized adultery. Now, what is the background to this case? Now, one non-resident Indian from Kerala, he had filed a PIL. And this public interest litigation challenged the offense of adultery under section 497 of Indian Penal Code, along with section 198(2) of Code of Criminal Procedure. So the constitutionality of both these sections of Indian Penal Code and CRPC were challenged. So we will try to understand what are these provisions and why these provisions are not constitutional. So a 5-judge bench started hearing on the PIL in the month of August 2018, and finally the bench delivered its judgment on 2018 and they decriminalized adultery. This section 497 of Indian Penal Code was scrapped. So first of all, we need to understand what exactly are these provisions, section 497 as well as section 198(2), and how they were unconstitutional. Now, section 197 of Indian Penal Code, it criminalizes adultery. It imposes culpability on a man who engages in sexual intercourse with another man's wife. So let's say we have a couple here, and then let's say there is another couple. So the square box here denotes the husband, the triangle denotes the wife. Now, if this guy has sexual relations with this female, so H2 can file a case against H. So culpability on the man if he is engaging in sexual intercourse with another man's wife. This was the case. But see, one thing has to be noted here, that this female W2, she is also engaging in adulterous behavior. She is also equally part of this equation, the sexual intercourse that they had, the intimacy that they had. But W2, this female, will not be charged for it. She will be exempted from prosecution. And this man who has engaged in the sexual intercourse, he might be imprisoned for 5 years. So, this particular law is not gender neutral. The man is punished, but the female who also engaged, who was equally part of the relationship, sexual relationship, is not equally punished for it. Now, apart from this lacuna, drawback, there is another challenge also. If the husband engages in sexual intercourse with an unmarried woman, this section is not applicable. For example, let's forget this equation. So husband, wife, they are there, they're a couple. Now let's say there is another woman who is unmarried. Now, if this person engages in sexual intercourse with this unmarried woman, this section will not be applicable here, even though it also consists adultery. He is having a relationship outside marriage. So it is not gender neutral. The married woman is exempted from prosecution. Apart from that, if the husband engages in sexual relationship with an unmarried female, it is also not covered under the ambit of this particular section of Indian Penal Code. So these are the inherent drawbacks of this particular section. Now, what is section 1982 of Code of Criminal Procedure? Now, section 1982 of Code of Criminal Procedure, CRPC, it just tells you the procedure, how a complainant can file charges for offences committed under 497 section of IPC. And here one thing has to be noted. Under this provision, only the husband may file a complaint for the offence of adultery. So husband wife here. This person engages in sexual relationship with the wife over here, wife too. So only this person can file a case against this person. So H2 can charge against H1. The woman cannot file a case here against her own husband as under section 497 of IPC. So this is again another drawback. So only husband may file a complaint for the offence. So this is about section 497 and section 1982 of CRPC. So from these two pieces of law, what are the issues that we can identify? First issue, exemption is given to married women. She will not be charged for adultery. Second thing, section 497, whether it should be made gender neutral, whether women should also be tried as offenders. That is again another issue here. Apart from that, it is also questioned whether the penal provisions are quite excessive in nature. 5 years of imprisonment. There are other cases, other kind of offences in which the penal provisions will be comparatively less. So, is 5 years of punishment too much, too harsh? And whether we should be making this law gender neutral so that we can include women as offenders. So all these three things needs to be discussed, needs to be debated. And that is what was taken up by the Supreme Court. And they analyzed along all these things, along all these lines, and they gave their judgment. So what was the analysis by the different judges of the Supreme Court? Now, first point that is being highlighted here is this particular section of Indian Penal Code, section 497, is arbitrary. Now, one of the argument given in favor of section 497 was that it preserves the sanctity of marriage. Because of this provision, marriage as an institution can be maintained. The sanctity of marriage can be preserved. But just look at it, it might not be the case. Now, just think about a scenario in which the husband is giving consent to his wife to have sexual relationship with some other man. So, in that scenario, section 497 will not be applicable. But at the same time, marriage as an institution, it is not getting preserved here. So, the idea of sanctity of the institution of marriage might not be preserved by this. Apart from that, this particular law serves to preserve the notion that the husband has rights over the wife. Husband has control over the wife. Or indirectly we can say it assumes that wife is the property of an husband. Now just look at the entire scenario. Why this thing would have come into being? Husband 1 is having sexual relationship with wife 2, and H2 can file a complaint against H1. Now, why do you think this law would have come into being in the first place? Now, if you trace the roots, we can trace the roots to the Victorian period. Now, at that point of time, in the past, women were considered to be the property of their husbands. So, what is happening here is H1 and H2, their property is W1 and W2 respectively. No. Now, when H1 is having sexual relationship with W2, it can indirectly refer or it can indirectly imply that he is taking away the property of H2. This is how women were perceived at that point of time. They were not perceived to have their own agency. So, this is basically being assumed to be a conflict between H1 and H2. W1, W2, they don't have any say here. That is the reason only H2 can file a complaint against H1. Since H1 has basically stolen the property of H2 or has attacked the property of H2. So the idea behind this law is these notions. So this kind of notion is not right in the present times. It does not stand the test of time. So, since this law serves to preserve the proprietary rights a husband has over the wife, it must go. Apart from that, in this law, women cannot file a complaint against her husband or his lover. So this is also not correct. It is not gender neutral. Only man can complain, the female cannot complain. So gender neutrality is being questioned. Apart from that, in this particular law, there is no provision to deal with a married man having an affair with a unmarried woman or a widow. That provision is also not there. Only if that female is married, then only these law will be applicable. So that is the reason section 497 is considered to be arbitrary. Apart from that, here the notion is the husband is owning his wife, has full control, full ownership over his wife. So the idea that the wife is the husband's property is being perpetuated, which is wrong. Apart from this section 497 being arbitrary in nature, the other argument given here is that it is justifying that the husband has control over the wife. The sexual autonomy and dignity of a woman is directly dependent on the husband. That is also something which is not correct. Equality should be the governing parameter. Husband, wife, they should be considered equal. Why should the sexual dignity, the sexual autonomy of the wife be dependent on her husband? So this is again another ground on which this law has been questioned. Also, this particular law is against Article 1415 of the Constitution, right to equality. So it is against that. So section 497 violates the provision of Article 1415 given in our Constitution. Apart from all these things, the Supreme Court also analyzed whether adultery should be considered as a criminal offense. Now, what is happening here is when you are trying to criminalize adultery, you are basically entering into a private sphere. Now, whether adultery is a public wrong, whether it is a moral wrong, it is a moral wrong, it can be a moral wrong. If you are into a marital alliance and you are engaging in sexual relationship outside the marriage, yes, it is a moral wrong. Infidelity is there. But is it a public wrong? Is it impacting a large number of people in the society? Or is it just between the individuals and their family members? So again here, the Supreme Court analyzed it and they are saying that it is a moral wrong rather than a public wrong. So if it is not a public wrong, why should it be made a criminal offense? And the Supreme Court judgment, it says that the autonomy of an individual to make his or her choices with respect to his her sexuality in the most intimate spaces of her life should be protected from public censor. So your sexuality, your sexual choices, they are quite personal. They should be limited to the personal space. They should not be exposed to public censor. So that is the reason it is saying that it should not intrude into that sphere. So it should not be considered to be a criminal offense, and it is a moral wrong rather than a public wrong. So that is also another reason why adultery should not be considered as a criminal offense. So based on all these arguments, adultery was decriminalized. So the section 497 of the Indian Penal Code was scrapped, and since the substantive provision went down, so the procedural provision 198 of CRPC, that also has to go down. This was what was the exact statement of Justice Deepak Mishra. So this is about adultery. So what is adultery? What were the provisions? Why it was struck down? Keep this in mind, that what is the underlying notion behind the laws that we had. The underlying notion was man used to consider women as his or his own property. Man used to govern women's sexual choices. Women's sexual choice, her autonomy was dependent on the man. So this was the underlying notion. It impacted laws in different parts of the world, and again that is also impacting our laws. Our laws are also from the remnants of the past, colonial laws. So that is how it has come down. This particular law goes against the principle of equality, 1415 of the Constitution. We need to have egalitarian gender neutral laws. It was not a gender neutral law. It was punishing male members, not the female. Unmarried female were given exemption. Women were not considered as offenders. So because of all these things, this particular section, this particular law has been scrapped down. So this is about the recent judgment related to adultery. Now the next topic that we'll take up is the issue of triple talaq. So why was the practice of triple talaq in news in the last few years? So two things why it was in the news. First reason, now a PIL was filed, Supreme Court was hearing that PIL and it gave its final judgment. According to that judgment, the practice of triple talaq is unconstitutional. So triple talaq is against the Constitution. So here the judgment was given by a 5-judge constitutional bench, and three of these judges said that triple talaq is unconstitutional, and then there was a dissenting opinion by 2 judges. So we'll understand on what grounds they have declared triple talaq as unconstitutional, and we'll also try to understand what were the dissenting opinions. Apart from this particular judgment, what else is the reason why triple talaq was in the news? Now, after triple talaq was declared unconstitutional by the Supreme Court, the government tried to initiate certain reforms, legislative reforms. Now, what they are trying to do here is they initiated a bill, and this bill criminalizes triple talaq. That means if a man, despite Supreme Court declaring that it is null and void, it is unconstitutional, even despite this, if he tries to use triple talaq, then he might be charged for it. It will be considered as a criminal offense as per the bill that was brought to the parliament by the government. The bill could not be passed in Rajya Sabha. It was only passed in Lok Sabha, and the government tried to use some other mechanisms. For example, they brought about an ordinance as well, and they have promulgated the ordinance multiple times. The bill will be lapsing with the dissolution of Lok Sabha. But what is important is we need to understand the provisions of this bill, because you never know, the next government whoever will come to power, if, for example, if the NDA government is coming to power, they might again initiate the bill, or they might again bring some other, they might initiate some of the efforts in this particular direction, in the same direction. So that is the reason we will try to understand some of the features of these bills and what are the positives, negatives. So first thing what we will do is we'll understand the verdict and what is the background to the verdict. So what is the background to the Supreme Court judgment? Now in 2016, one female, Shaira Bano, who was married to Rizwan Ahmed for 15 years, this female was divorced through triple talaq. So in 2016, she is being divorced by her husband through triple talaq. What is triple talaq? 3 times you are using the term talaq and instantaneous divorce is there. So now this female, Shaira Bano, she is filing a petition to the Supreme Court. And she is saying that 3 provisions. The provision of triple talaq, talaq-e-bidat, polygamy, nikah halala. All these 3 provisions should be declared unconstitutional. So for that she is filing a petition. Now what are these 3 things? Talaq-e-bidat, nikah halala and polygamy. So we need to understand that how they are, what are they and what is the difference between them. So basically the petition is filed against all these 3 things. Now talaq-e-bidat means it's a practice which gives a man the right to divorce his wife by uttering talaq 3 times in one sitting, even if there is no consent from the side of the wife. So it is a unilateral mechanism of divorce. The husband, the man, utters talaq 3 times and instantaneous divorce is there. So this is called talaq-e-bidat. What is nikah halala? Nikah halala means a practice. Nikah halala refers to a practice where a divorced female, if she wants to remarry her husband from whom she has been divorced, if she has to do that, she has to obtain divorce from a second husband before she can go back to the first husband. So this is a couple. Now let's say they were divorced. If W1 wants to again get married to H1, she has to first get married to some other person, has to get a divorce here, and then she can marry her former husband. So this provision is nikah halala. Now Shaira Bano, she is filing a petition to again declare nikah halala as unconstitutional. Apart from that, the petition also talked about polygamy. It is saying that polygamy should also be made unconstitutional. Polygamy is the practice in which a man is having, Muslim men have multiple wives. Under their law, under their personal laws, they can have multiple number of wives. So these 3 things are being questioned, these 3 things are being challenged. So now, from all these things, what are the core issues that we can identify? So basically, there are 2 issues here. First thing, whether this practice of talaq-e-bidat is an essential practice under Islam. If it is an essential practice under Islam, then it might enjoy some constitutional protection. Right to practice, profess your own religion. That is one of the fundamental rights. So, if it is an essential practice under Islam, that or not, that is something we have to identify. That is what the Supreme Court tried to do. Apart from that, another issue is whether triple talaq violates fundamental right. Different fundamental rights are there. Is triple talaq violative of some of the fundamental rights? These were the key issues which Supreme Court tried to analyze. Now, what were some of the arguments in favor and against this? Now, who were the ones who were supporting these provisions? Who were the ones who were against these provisions? Now, apart from Shaira Bano, there were many other women right bodies who were against these provisions. For example, many women rights organizations like Beba Collective, Bharati Muslim Mahila Andolan, they were also against these provisions. They also wanted these provisions to be declared unconstitutional. But at the same time, there were some other bodies, for example, All India Muslim Personal Law Board. They were supporting these provisions. They, according to All India Muslim Personal Law Board, they are saying that this Muslim personal law is not subject to constitutional judicial review. They are all essential practices of Islamic religion, and they are all protected under Article 25 of the Indian Constitution. Right to practice, profess, propagate your own religion. So, under Article 25, they are all protected and they are all personal laws. So now, what was the judgment of the Supreme Court? Now, as I told you, it was a 3:2 judgment. 3 judges were against these provisions. They declared it unconstitutional, while there were 2 judges who had a dissenting opinion. So we'll try to understand the majority opinion as well as the minority opinion. Now, Justice Rohinton Nariman and Yulu Lalit, they are saying that the practice of talaq-e-bidat is unconstitutional because it is arbitrary. It is arbitrary in nature. A man, on the basis of his own whims, can move out of the marriage. He can whimsically move out of the marriage. He can capriciously move out of the marriage without making any effort to save the marriage, without making any effort to reconcile. So it is quite arbitrary in nature. Since it is manifestly arbitrary in nature, it should be declared unconstitutional. As per Justice Nariman as well as Justice Lalit. Justice Kurian Joseph looked at it from another angle as well. Justice Kurian Joseph says that triple talaq is against Quran. Since it is against Quran, it also lacks legal sanction. What he is saying is, what is held to be bad in Quran, Holy Quran, cannot be good in Shariat. So what is bad in theology is bad in law as well. So he is looking at it from a religious perspective. Since Quran itself considers triple talaq to be bad, so that is the reason it should not be part of the constitution as well. It should be struck down. Nariman and Lalit, they looked at it from another angle. They are saying it is arbitrary in nature. So 3 judges were against the provision of triple talaq. Now Justice Kehar and Justice Nazir, they are saying that the practice of triple talaq is intrinsic part of the personal law, and since it is part of the personal law, it will also have some safeguards. It will enjoy protection under Article 25. For this, they are referring to the Constitutional Assembly debates, and from there, they are tracing it. So they are saying that there will be protection under Article 25. Another thing they are identifying here is the solution to all these things. See, this practice is there, but it is definitely gender discriminatory in nature. That is something they are also identifying. Women, they do not have sufficient safeguards, so they are more vulnerable. So it is gender discriminatory. They feel this gender discriminatory nature of triple talaq can be taken care of using legislative action. In fact, they are of the opinion that immediately after the verdict, for 6 months, the provision of triple talaq should remain inoperative. Within this particular time frame, legislature should come up with some law which can ensure that the triple talaq no longer remains gender discriminatory. So here also you can see that even if it is a minority opinion, even if it is a dissenting opinion, the dissenting opinion is also egalitarian in nature. They also want to do away with the gender discriminatory provisions. So this is how the different judges looked at the issue of triple talaq. And since the majority was in the favor of triple talaq being unconstitutional, it was struck down. But after the Supreme Court judgment, the government, it felt that it needs to bring about a law to criminalize triple talaq. The government quoted that despite the Supreme Court judgment declaring triple talaq to be unconstitutional, there have been instances of triple talaq. So that is the reason they are bringing a law in Parliament. They're introducing a bill in Parliament. They're introducing it in Lok Sabha. So what is this law about? Why this law they are initiating? And what can go wrong with the law? We'll try to analyze that. So the first thing, the judgment, after the judgment of the Supreme Court, on 28th December 2017, the Muslim Women Protection of Rights of Marriage Bill is introduced in Parliament in Lok Sabha. And in the same day itself, it is passed by the Lok Sabha. But when it goes to the Rajya Sabha, it is stalled in the Rajya Sabha by the opposition parties. In 19 September 2018, the government is initiating an ordinance, Muslim Women Protection of Rights on Marriage Ordinance. Since they were not able to pass the law, since they were not able to pass it in Rajya Sabha, so they are now initiating an ordinance. But an ordinance cannot be there for a sufficiently long period of time. Within 6 weeks, it has to, once you have introduced the ordinance, once the legislature is in session, within 6 weeks, it has to be passed by it. So again, December 17, 2018, we find that the bill is again introduced in Lok Sabha. It is passed by Lok Sabha on December 27, 2018. And again, this particular law has not been passed in the Rajya Sabha, and the ordinance has been promulgated again and again. With the dissolution of Lok Sabha, this particular bill is also going to lapse. Now, what are the provisions under this particular bill? And the provisions of the bill, they're also the provisions of the ordinance that is there right now. So what are the key provisions of the ordinance as well as the bill? Muslim Women Protection of Rights on Marriage Bill 2018. Now the first thing, this bill declares talaq, including written electronic form, to be void and illegal. And it also defines what exactly is talaq. So it defines talaq, and this talaq in different forms, maybe written form, maybe electronic form, all the forms are void. So what exactly is talaq as per the bill? Now, talaq here refers to talaq-e-bidat or any similar form of talaq pronounced by a Muslim man which can result in instant irrevocable divorce. So instantaneous divorce. So talaq-e-bidat, we already know what is it. 3 times if you are pronouncing talaq in one sitting, that is talaq-e-bidat. So this is considered illegal. Apart from that, any other form which leads to instant divorce, they will all be considered to be illegal. They will all be considered to be void. Now, what kind of offense is this, and what is the penalty for it? If the bill comes into being, and after that, if a man uses triple talaq-e-bidat or similar kind of provisions, then he can be imprisoned up to 3 years, and he can also be charged a fine. So this is the penal provision, this is the punishment. It is a cognizable offense. Under what circumstances it is cognizable? It is cognizable if information relating to the offense is given by the married woman who has been divorced, or against whom the words talaq has been pronounced, or by any other person related to her by blood or marriage. Both the things are there. So blood or marriage, the woman herself and any of her relative with whom she is connected by blood or marriage. So if these people are giving information, or the woman is giving information, then it will be cognizable. Whether bail can be given in this kind of offense. The magistrate may grant bail to the accused, but only after hearing the woman. So magistrate will hear the woman, then only the bail will be given, and only when the magistrate is sufficiently convinced, sufficiently satisfied that there are reasonable grounds for granting the bail. Now, whether this particular offense is compoundable. Compoundable means whether there can be a settlement between the two parties. So, this particular offense is compoundable It can be compounded by magistrate upon the request of woman. So if the woman is requesting the magistrate that they can go for compounding, then it is compoundable. And the terms and conditions of compounding will be determined by the magistrate. So it is a compoundable, cognizable offense. Under this law, is there any provision for allowance for the aggrieved woman? The aggrieved woman can seek subsistence allowance from her husband for herself and her dependent children. And she is also entitled to seek custody of her minor children. So these are the different provisions under this particular bill. And thus the provisions of the ordinance are also the same. Now, we understood the provisions, but can we identify some issues with these provisions? What has been some of the criticism of this particular bill? Now, issues. The first issue here, the marriage between a Muslim man and a Muslim woman is considered to be a civil contract. So the union of the Muslim man and the Muslim woman is considered to be a civil contract. But here what we are trying to do is, we are considering the breakdown of the marriage as a criminal wrong. So, a civil wrong is being converted into a criminal act. So if the marriage is a civil act, the dissolution of the marriage should also be a civil act. But that is not the case. Marriage is civil act and the dissolution of marriage is being considered as a criminal act. Second thing, how many instances are there in which criminalization leads to deterrence? Can criminalization lead to deterrence? That is the question. If it is made a criminal act, will it serve as a deterrence against commission of this act? That is the question. So many instances are there in which it has been found that if the penal provisions are made harsh, not necessarily it becomes a deterrent. There can be some other causes why this thing is prevailing. So criminalization might not have a deterrent act. Apart from that, already there are multiple laws against inflicting different kind of cruelty. Already we have different kind of legal provisions. If already so many legal provisions are there, why do we need one more law? For example, we have Protection of Women from Domestic Violence Act. Now this particular law talks about abuse that is meted to women within the household. It talks about different kinds of abuse and it talks about different threats of abuse. For example, it can be physical abuse, verbal abuse, economic abuse, different mental abuse, different kind of abuses are included here. So if all these provisions are already there, why do we need one more law? See what exactly this particular law is doing. The law that the bill that was introduced in the Lok Sabha. So whenever a husband is pronouncing talaq to his wife, so we are assuming that she will be undergoing different kind of trauma, she will be undergoing different kind of abuses. So for that abuse, you can use Protection of Women from Domestic Violence Act. Why do we need a separate law? That is the question here. Apart from that, some experts, they have pointed out another flaw. Now, this particular law will come into being when the particular man goes for an instantaneous divorce. When that man is saying talaq, talaq, talaq or some other form of that. What will be the scenario or how are you going to handle those scenarios in which the man is not using the provisions of talaq which has been defined as per this law? So, abandonment of wives is not considered here. And there is no protection for this abandoned spouse. And one thing has also been highlighted here. In case of India, there are more than 2 million women who are separated, who are abandoned. And 1.8 to 1.9 million of them are Hindus. So for abandonment of women, we do not have any specific provision. But for triple talaq, which leads to abandonment, we are having some specific provision. If Muslim women need protection from abandonment, don't you think Hindu women also need protection from abandonment? But in such a scenario, for them, there is no such protection here. So, again, this is questioned here. criminalizing desertion by Muslim women, but not criminalizing desertion by Hindu men or Jain men or Sikh men. It is also discriminatory. Why should Muslim men be penalized for the same thing, and why Hindu men or men from other religion, they will not be penalized for the same activity, same action, same act? So this leads to discrimination. Why are different religions being treated differently? At the end of the day, women are being subjected to abandonment. They are not having any protection. So why only one section of the population, they are criminalized? Why not others? Apart from that, this particular law, it is not talking about any economic or socio-legal support from the side of the state to the women, to the children, to her dependents. It is talking about compensation that men might have to provide to women and their counterparts, but it is not talking about the support that they should get from the side of the state. There are some other laws through which women might get support in case they are facing domestic violence or some other issues. But here, the law is not specifically focusing on that. So no support from the side of the state. Apart from that, another lacuna has also been identified under this particular law. Now, as I told you, this is a cognizable offense. It will be cognizable if the information is provided by the aggrieved woman herself or by the relative of that woman. The relative can be a blood relative or it can be a relative through marriage. Now, this particular clause has also been criticized. Just think about a scenario in which there is a interreligious marriage. The man is Muslim, the woman is Hindu. So in such a scenario, the man can be charged wrongfully by the relative of this female, blood relative of the female. So, interreligious marriages of Muslim men with women of another religion, in those scenarios there can be issues, there can be conflicts. Apart from that, the terms of imprisonment, 3 years, is also considered excessive, arbitrary and excessive. Just think about it. If one is causing death by rash or negligent act, the punishment is 2 years. If one is involved in rioting, so then also the punishment is 2 years. But here the punishment is 3 years and also a fine. So the terms of imprisonment is arbitrary and excessive. On these grounds also it has been criticized. So these are all different issues with the present bill that was initiated in the Lok Sabha. So this is about triple talaq, the issue of triple talaq, the judgment related to triple talaq, and the recent efforts by the government to criminalize triple talaq. Now the next topic that we'll take up is female genital mutilation. So what is female genital mutilation and why was it in the news? So this is something which we are going to understand now. Now, the practice of female circumcision, which is also referred to as khatna, khafs, it has been practiced among some communities in India. In fact, it has been primarily practiced among the Dawoodi Bohra community. Also, there have been some instances of this particular practice among some Sunni Muslims in Kerala. So, keep this in mind. Khatna, khafs, female circumcision among some communities. Now, what happens in this process? Some portion of the female genitalia is removed. Generally, the clitoral hood is removed. Now, why do you think these kind of practices will be there? A portion of female genitalia is being removed, and generally this takes place when the female is quite young. Among some communities, it is among the toddlers. Among some community, it is between the age group 0 to 15 years. So, one of the reason why this is done is this particular mechanism. It regulates or it seeks to regulate female sexuality and sexual desires. Now, female genital mutilation can be again of different types practiced in different places. Even though it has been banned, it has different international experts, commentators, they have tried to eliminate these kind of practices. But despite that, it is practiced and in different forms. So in some places the clitoris might also be removed. Now, if the clitoris is removed, it can lead to a situation in which the female will not enjoy during the sexual processes. So what is happening here is you are regulating the sexual behavior of a female by these processes. So sexual relations should be maintained for childbirth. It should not be for deriving pleasure. So that is one of the notions behind these practices of female genital mutilation. One thing here you should note, I use the term female circumcision, khatna, cuffs. Another term I'm using is female genital mutilation. Now, female genital mutilation will be the larger category under which there will be different kind of mechanisms. So, one such method is female circumcision, and that is referred to as khatna cuffs among some communities in India and primarily the Bohra community. Now, why this thing came into the news? Now, this has been an age-old practice among some sections, but why it has been in the news all of a sudden? Now, Sunita Tiwari, one human rights advocate, she had filed an PIL for banning this practice. And according to her, this particular practice is a kind of female genital mutilation. Female circumcision is a type of female genital mutilation, and it is violating different rights of women. It is violating women's right to equality. It is violating her right to privacy. It is also violating her right to personal liberty. So on these grounds, she has filed the PIL, and so that Supreme Court can hear it and declare that these kind of things should not be carried out. On 24 September 2018, the Divisional Bench of Supreme Court, they referred into the Constitutional Bench. So the Constitutional Bench is going to decide now. So right now, the final judgment has not been there. It can be there in a while, so that is the reason it becomes important. So first thing, what we will try to understand is, what is the prevalence of these kind of things in case of India? And what is the international experience? Do we have any international convention which talks about these kind of discriminatory practices, inhuman practices? So we look at all these things and finally we will understand the issue in details. So the first thing, how prevalent is these practices? Now it is said that at least 200 million world over, 200 million women world over have undergone some sort of ritual cutting in their genitals. 200 million, 20 crores. I'm not talking about India. This is the number for the entire world. And in case of India, this is carried out secretively. There is not quite there in the open. Secretively, it is practiced, but it is prevalent. And generally, the traditional cutters, mulanis, they are the ones who carry it out. In some instances, doctors also carry it out. Now, when it comes to the numbers, how many numbers of female circumcision takes place in India or has taken place in India in last few years? The state, the Ministry of Women and Child Development, they said that they do not have any official data. They do not have any study which supports the existence of female genital mutilation in India. So from the side of the Women and Child Welfare Ministry, we do not have sufficient data. But some independent studies have been carried out. The first ever study about female genital mutilation in India, it was found out that half of the women who had undergone this thing, they felt some sort of irritation. 30% of them feel some sort of discomfort when they are walking, urinating, and some of them felt that they have lost sensitivity in the area. This was found out by Dr. Shujat Wali. She had examined Bohra women. Now, when it comes to the practice, how old is this practice, or what is the root of this practice? What is the origin of the practice? Dr. Zeenat Shaukat Ali, one of the professor of Islamic studies, says that this particular practice is not based on Islam. It is not something specific to Islam. Zeenat Shaukat Ali says that it is something which is very, very specific to Dawoodi Bohra community. Among the communities prevalent rather than among Islam. So the roots might not be there in Islam itself. So this is about the prevalence. Now, if you look at the roots, or what could have been the possible reason why this particular practice came into being. Now, again, this particular practice will be rooted in sexual pleasure. Women have been subjected to dominance under men. They have been subjected to a patriarchal society. So the patriarchal ideas of purity and modesty, that forms the basis of these kind of practices. Now, what do we mean by this? Now, if the clitoral hood or the different parts of the clitoris are removed, it can lead to loss of sensitivity. We already saw that, and this has been proved by the recent first ever survey on women who have undergone these kind of procedures. So this can be a mechanism by which the sexual desires of the women can be controlled. This can be one of the mechanism by which the sexual relationship intimacy of women can be controlled. So the idea of purity and modesty, that is also coming into play here. Women should be pure before marriage. They should remain pure, and this is one of the mechanisms by which their purity can be maintained. So the patriarchal ideas of purity are being reinforced by these kind of notions. So the practice of female circumcision, you can say that it is rooted in the belief of family honor, maintaining family honor, maintaining virginity, not having promiscuous behavior. So these are the roots of female circumcision. Now, because of this practice, what can be the possible challenges that a female faces? Now, this practice can lead to serious health concerns, can lead to severe pains, can lead to excessive bleedings, can also cause problems when it comes to urinating. Many times, these kind of practices are not done by doctors. They are carried out by those people who do not have any such medical experience. They do not have any such training. Now, it can lead to infection. It can lead to cysts. It can have impacts for longer durations. Lifelong impact can be there. It can create issues during childbirth as well. Can cause physical impairments. So, physical health wise, it has a lot of risks. But it is not only the physical dimension. These kind of practices can be traumatic for an individual. Just imagine a female, a child, a girl child has to undergo these things. So it can be traumatic for her, and because of this trauma, there can be large scale, long term psychological consequences. So major health concerns are there, both for physical health as well as mental health. And these kind of practices, they're also serious rights violation. Human rights, fundamental rights are being violated in this process. For example, right of women to equality, non-discrimination. Women
Come on, buddy.
are subjected to these kind of procedures, these kind of painful, harrowing procedures. Why they are subjected to these procedures? Also, these kind of procedures are a violation to the right to security and physical integrity of a woman, bodily integrity of a woman. If a part of your body is removed, that means your bodily integrity, your physical integrity is threatened. So, right to security and physical integrity is also questioned. Apart from that, this particular procedure also violates one's right to highest attainable standard of health, because it is impacting the female physically as well as mentally. There can be pain, there can be bleeding, there can be issues when it comes to urinating, menstrual periods. There can be issues. So you are not able to attain the best standards of health. Apart from that, it also violates one's right to be free from torture. It is a kind of inhuman practice. It is a kind of torture. Apart from that, these kind of practices are carried out on female who are in the age category of 0 to 15 years, children. So it is also impacting the rights of a child, violation of the rights of a child. Even United Nations Convention on the Rights of the Child also talks about it. So multiple kind of rights are being violated by these kind of procedures, female genital mutilation. Now, what are some of the international opinions when it comes to female genital mutilation? See, one thing you should keep in mind, female genital mutilation is not something which is specific to India. In fact, in India, the prevalence is less. There are some other places which has rampant practices of female genital mutilation. For example, the sub-Saharan Africa region, where it is even more widespread. So, it has been identified as a global concern by different agencies. For example, the World Health Organization, it says that female genital mutilation is gross violation of the rights of girls and women. So it also calls for action against these kind of practices. Similarly, United Nations General Assembly in December 2012, it adopted a unanimous resolution calling for elimination of female genital mutilation. Apart from this, there are many countries which have taken steps on their own. They have banned these kind of practices. Countries like US, UK, Australia. In fact, some of the African countries have also gone ahead and banned FGM, female genital mutilation. So, a female genital mutilation has been banned, or at least it has been criticized in different kind of international forums. But what is stopping India from banning it, or at least for making laws so that all these practices can be curbed? Now, some arguments have been put forward against the curbing of practices of female genital mutilation, female circumcision. Now, first thing, it is considered to be a religious practice. So the advocates, they say that it is a religious practice. Now, since it is a religious practice, it is part and parcel of their religion. So it is protected under Article 25, Article 26 of the Constitution. Some of the fundamental rights of the Constitution. Second thing, one ground we said that it violates is it is a discriminatory practice targeted against women. Now, this has also been challenged. So the advocates of female circumcision, they are saying that this practice is not discriminatory against women. They are saying that male members, they also have to undergo circumcision. So for example, among the Dawoodi Bohra community, the male members are also required to be circumcised. So it is not just women, it is men as well. Both have to undergo this. Now, one particular organization, Dawoodi Bohra Women for Religious Freedom, DBWRF, it says that it is the representative of around 72,000 Dawoodi Bohra women. Now, they say they are also in favor of female circumcision. They are against any interference into their religious practices. So what they are saying is, the procedure of female circumcision that is practiced among the Dawoodi Bohra community, it is different from female genital mutilation. So female circumcision, that is khatna, and female genital mutilation, they are not the same things. They are saying they are two different things. And what they are saying is, when it comes to khatna, or the kind of practice they have in their community, it is not that painful. It does not involve mutilation. It is more of a harmless procedure. It is just a nick. It is not complete mutilation. That is what they are saying. And they are saying that if someone does not want to have it, then it is not enforced. Also, they are saying that if someone does not want to have it, it is not enforced. Apart from that, they are also saying that there is no scientific evidence that the procedure affects the physical, emotional, psychological health of a woman. And they give so many instances among Dawoodi Bohra women who have undergone this procedure, and they feel that they have not had any of these impacts. But one thing you should note here is, they might claim it to be a harmful procedure, and mutilation is not involved. But the point here is, most of the things are done in secrecy. So again, on those grounds it can be challenged. Apart from that, they are saying that it is not enforced on those who do not want it. But see, on whom it is being enforced? On minors. Those who are in the age category 0 to 15 years. And who are the ones who decide for them? Their parents. Now, the parents are deciding for their minors. The minor does not have any consent, and the minor, once after becoming adult, will get impacted by it. So that particular adult did not have any say in the decision. So on these grounds also, it can be challenged. So these are some of the arguments against curbing the practice of female circumcision. First thing, it is a religious practice. It is part of religion. It is fundamental to the religion. So it should be given constitutional protection under Article 25-26. It is not discriminatory. Circumcision happens for men as well as women. Third thing, it is not exactly female genital mutilation. Female genital mutilation is different. Female circumcision is different. Here, mutilation is not there. A small nick can be there. And in case someone does not agree with it, someone's parents does not agree with it, they don't have to necessarily go through it. No scientific evidence that this procedure can affect the physical, psychological, or emotional health of a woman. This has been the arguments put forward by some of the advocates of female circumcision or karna. So what are the issues, the broader issues that needs to be analyzed, that needs to be tackled, and that is what will be considered by the Supreme Court in its final judgment. The Constitutional Bench will take it up. So first thing, whether the practice of female circumcision violates the right of privacy of the girls on whom the procedure is performed without their consent. They are minors, 0 to 15. Without their consent, this procedure is being carried out and they have no say over there. And they are going to get impacted by the procedure later on. They might get impacted by the procedure. Apart from that, another major issue here, whether the practice violates the right to life and bodily autonomy of women and girls and infringes Article 21, right to life, right to personal dignity. Are these being violated? Women might not enjoy sexual relations later on because of this process. Her bodily integrity is being questioned. If bodily integrity is not there, so is it not a violation of the right to life, right to dignity? Apart from that, whether the practice is discriminatory against women and girls, if it is discriminatory, then it is going to violate Article 14 and 15 of the Constitution. Apart from that, whether the practice is a religious practice, whether the practice is fundamental to religion, in such a scenario, Article 25-26 will get protection under Article 25-26 of the Constitution. So all these things need to be analyzed. On all these bases, there will be the judgment of the Supreme Court. So this is the debate related to female genital mutilation, female circumcision in India. The next major issue, which was in the limelight last year, was the issue of entry of women into Sabrimala temple. Now, why was this issue in news? There was a Supreme Court judgment related to it. Now, what was the judgment about? And what has happened post the judgment? This is something that we are going to focus on in this session. Now, first of all, why it was in the news? Now, there is a temple of Ayappa, Lord